So welcome everybody to the latest Brain or Shine webinar with myself, Mark, and this is Jules.
Hello and good evening.
Yeah, and below us on the screen, on our screen, we have Racheal as well, who will let you introduce yourself. But welcome, Racheal, and thanks for coming along this evening.
Thanks very much.
Oh, bless you. Thank you. Racheal's from Slater Gordon, and she's going to be hosting or co-hosting our RC Expert webinar this evening. If you're joining for the first time as well, everything that we talk about in Brain or Shine is through lived experience, and we team up with Slater Gordon for their expert advice as well. They're a firm of lawyers based in the UK. We appreciate that some people watching may be from other countries, and obviously the laws and what Racheal's going to tell you might be slightly different where you're dialing in from as well if you're not in the UK. So do bear that in mind. But we can always help to signpost people if you're not sure. We've got a lot of contacts through the brain injury community on various different sites as well. So, and I'm sure you know people in your areas as well. But anyway, let's hand over to Racheal for some information about wills, trusts, powers of attorney, probates. And the reason why we've got invited Racheal along today is because I really struggle with paperwork. I really struggle with processes, and I really struggle with legal terminology and anything like that at all. So they're things I totally avoid doing. And this is going to make your understanding and our understanding a lot easier of these really, really difficult subjects, maybe. So welcome, Racheal, and thank you for joining us this evening.
Thanks very much for having me, guys. Hello, everybody. So if we could have the first slide, please, which is just an overview of what I'm going to be talking about. So these are my specialisms, really, and those of my team. We sit within Slater Gordon Lawyers, which is a personal injury and medical negligence specialist firm, but we also do lots of family law, employment, court of protection work, and my team does this kind of work. So we do everything from helping people plan their current finances, legal matters, all of that kind of thing, putting into place their wills and their powers of attorney. But we also deal a lot with bereaved families, helping them through the probate procedure and dealing with things after somebody's passed away. We also deal with trusts at every stage of the process. So where somebody's either set up a trust during their lifetime to look after a vulnerable person or has created one in their will for after they've passed away, we help administer those trusts and look after that vulnerable person, whether that's an adult child, minor children, or, for example, a surviving spouse who might need some help. We help with that at every stage. As Mark said, while jurisdiction that we operate in is England and Wales, and that's just because that's where the law that we work under operates, we can advise on people who may have assets overseas, for example, and how you might want to make a will covering those, but we can't make them ourselves. And similarly, when I come to talk about lasting powers of attorney, then again, they operate within England and Wales. You can make them in other jurisdictions, but you will need specialist advice on that. So cooperating with foreign lawyers is always something that we can do, and we work very closely with them, for example, in Spain in particular, where people tend to have a lot of assets. But personally, England and Wales is our area of expertise. I've just mentioned on there the Society of Trust and Estate Practitioners, or TEP. You might have seen that after my name as a member. And this is the global benchmark body for people in this area of work. So if ever you do need advice, and it is in a particularly niche country, shall we say, if you have a look on the STEP website, then they do have a list of their practitioners in every country. So if a firm's listed there, you'll know that they know what they're talking about. And finally, just at the bottom, I've put our general inquiries email address. This appears at the end, and I'll talk again about how you can contact us if you have any specific questions. But I just thought I'd put that up front so that people know it's there. Okay, first page, please. So talking about a will first, what is a will? Essentially, it's a legal document which sets out your wishes as regards what you want to happen after you pass away. It has to be in writing, and it has to be executed, that is signed in a particular way. There are particular formalities to executing it, and it has to be done in a formal way. But other than that, there aren't that many requirements other than tradition. It's normally written on paper. It's normally done by a solicitor, so it's normally typed with specific precedents. But there's nothing wrong with a handmade will or one in a pre-pack that you get from WH Smith's, as long as it's done properly. Now, if you're confident doing it like that, then far be it from me to say, no, you have to go and pay loads going to a solicitor if you can do it yourself. But I would say, please make sure you are confident doing that, and only do that if you have the most simple and straightforward wishes. If there's any complexities, if you have any doubts whatsoever or any concerns about how to get it executed, please come and see a solicitor, because we just will make sure that you do it properly. You'll have all of that reassurance that it's all completely done in accordance with the law and in accordance with your wishes, and that you've got it right. So while those pre-packs or handmade ones do exist, I personally, and I would say this, I know, but I would say always please get professional advice just for your own peace of mind. So if you come and see a solicitor and say, right, I want to make a will, please, what are the kind of things we're going to ask you about? Firstly, we will ask you, do you have any thoughts about these things? But if you don't, and you say to us, look, I've got no idea, I need to talk it through, that's absolutely fine too. That's what we're here for, to explain to you what you need to think about and what the implications are. But essentially, it's this list here that we're going to be talking through. So firstly, we're going to be talking about your executors. These are the people who handle all the administrative matters once you pass away. They're the people who will be handling your paperwork, dealing with your bank accounts, your pensions, life policies, utility bills, your house, ultimately making sure that your estate is dealt with, all your assets are collected, debts are paid, and then everything's distributed to the people who you want to benefit. It's an administrative role. So just because you're an executor doesn't mean that you benefit from the estate. It needs to be somebody ideally who won't stress if they're asked to deal with lots of finances and paperwork. So choose somebody who you think has their own finances in order, for example, and who will be able to sort this out. I would say, though, that the first thing an executor can do if they want to is turn around and instruct a professional to help. So they don't have to do this all themselves. They can turn around to a solicitor and say, look, I'll make all the decisions, you know, come to me about selling the house, for example, but please, can you go away and do all the day-to-day work for me? You can appoint a friend or a family member as your executor, or both, or you can appoint professionals. So you can go straight to the solicitors and appoint a professional to act. Or you can appoint a complete combination. You might want to appoint a family member alongside a solicitor, and you've got then somebody close to the family making decisions, but a solicitor to do all the professional legwork. So that's the first thing to think about. Who's going to sort everything out? If you have young children, you might also want to think about appointing guardians. Any wishes that you put in your will are legally binding on the death of everybody who already has parental responsibility. So if you're the first of a parent couple to pass away, for example, then obviously the surviving parent still has responsibility for the children. But if something happens to both of you, then wishes put in your will are legally binding. And while obviously family or the courts or social workers can sort it out once you've passed away, actually having that will enforced in your possession and in your executor's possession just saves all of that bureaucracy, and may, particularly if you've had a detailed conversation with the person you've appointed, really save stress and grief for everybody at that particular time. The same goes for funeral wishes, really. These aren't in any way binding, but having an idea of what your funeral wishes are can be really useful, particularly if it's not something that you find easy to talk about to your family. And also, particularly if you think there might be any dispute over what happens. So they're not binding. If you change your mind later, that's no problem at all. And also, there is really no substitute for a conversation, because ultimately it might take a few weeks to retrieve your will from wherever it's been put away, in a drawer or with a solicitor, by which time it might be a bit late. So nothing replaces that conversation about what you want to happen, but it is traditional to include it in your will too. Then we move on to the substantive part of the will, which is what happens to everything that you own. You can make legacies of money or items that you own, your household goods, your possessions, your valued jewelry or cherished possessions. You can give them to anybody you like. So it might be, I give £500 to Brain or Shine for their charitable purposes. It might be, I give my watch to my son, I give my engagement ring to my daughter, I give my cherished painting on the wall to my next door neighbour who's always loved it. You can give anything like that that you want. Then we move on to what's called the residue, which is everything else. Once all your debts are paid, your funeral's paid off, any legal expenses are paid, the legacies have been distributed, house has been sold, everything's just collected into one big pot. What happens to that? And that's what's called the residue. And that's normally divided up into percentages. It might be, for example, you leave it to 100% to one person in the first instance. Like if you're a couple, you might want to leave everything to each other. And then on the second death, you can provide what happens then if you happen to be second to pass away. So, for example, everything to each other and then to the kids, or everything to each other and then half each to our respective siblings, or alternately to a charity, for example. You can have as many layers of substitution if you want. So you just keep on going like a workflow, really. Well, I leave it to this person. But if they die before me, then this person. If they die before me, then between these three people. If those three people die, then I want it to go to their kids. You basically tell us as solicitors, tell us what you want to happen, and we can make that happen. You might also want to consider putting trusts in your will. And there's a couple of different types, which I'll talk about on the next page. It's by no means compulsory, though. You may just want a nice straightforward will. This is what's going to happen. Once we've got that in place, then what would normally happen with a solicitor is that they will prepare a draft for you to have a look through. They'll talk through any questions that you've got, make any amendments that you want to make at that stage, and then they'll arrange for you to sign it. It has to be signed before 2 witnesses who have to be present with you at the same time when you sign it and they sign it and complete their details, all 3 of you together. That's really important. The witnesses can be your executors, but they cannot be beneficiaries under your will. So you cannot have as a witness anybody that you've left anything to. If you do, it actually doesn't invalidate the will, but it does invalidate their gift. So everyone else will get everything they've been left, but that poor old witness will not get what they've been left. So just keep any beneficiaries well clear. Find somebody independent. Okay. So that's what the process of making a will means, really. In terms of what then happens to it, you can either store it at home, or I generally recommend you put it in solicitor's archive, because fireproof, floodproof, all kept safe until it's needed. We could just go on to the next page. I'll just mention a little bit about trusts. I'm not going to go into this in detail, but I would be happy to speak to anybody on an individual basis if they want to contact me at another stage to talk about this. Essentially, if you want to make trusts for children, for example, I don't want them to have it till they're 18 or 21 or that kind of thing, you don't need to put that in. You just put, I leave it to my children on attaining the age of 21. And that just is automatic in the will. Your executors and trustees will look after it until they reach that age. Then there's other forms of trusts. A life interest trust is where the first person, or the person making the will, leaves their estate into trust for the benefit of somebody else for their lifetime. It's not that person's capital to hold, but they get the right to use all the trust property. Specifically, that means living in the house, for example, and it also means receiving income or dividends from any investments. Once that person who has the enjoyment of the trust property passes away themselves, then all the trust property passes to whomever the first one said in their will. So it doesn't pass under the second's estate. It goes right back to the first ones, and you say, right, well, what did they say to start with? Who does it go to now? And we find that that's very useful with families who have slightly more complicated relationships. So, for example, somebody wants to provide for their current partner, but at the end of the day wants their estate to go back to their kids from the first marriage, for example. Just something like that. It's an option. Discretionary trusts are more like putting everything into a big pot. Everything goes into a big pot, controlled by the trustees, who can then use it as they wish, or as guided by you informally by a letter that you might want to leave them. After your death, they have the discretion about which beneficiaries they pay to. The beneficiaries being the people who have the option of benefiting, but no right to it. It's important that they've got no right to it, because it means that for benefits purposes or any other kinds of means testing, this doesn't count as their capital. So again, I work with a lot of people who say, well, look, I want to leave this to my adult children, for example. I want them to have my estate, but I don't want them to get a great whack of capital into their own names. It will stop their benefits. They probably won't use it wisely. They might be taken advantage of, and I want someone else to look after it for them. And a trust will do that. If it's for the sake of one particular vulnerable person, then this last form provides particularly good tax advantages, where you limit the use of the trust purely for that person. And HMRC say, yeah, fair enough, we'll give you a loophole for that. And it is very good in a tax treatment sense. If everyone wants to hear more about that, then do come back to me. But I don't want to linger on that because I've got a lot else to talk about. So if we could just move on, please. Lasting powers of attorney. And I can see a question on the comment about setting up a power of attorney yourself, or do you have to go to a solicitor? Either. You can absolutely set up a LPA, as they're known as, lasting power of attorney, yourself. The forms are on the gov.uk website. Look them up. You can type into them online, download them, sign them. You can send them off to the Office of the Public Guardian and register them yourself. However, the same applies for a will. Only do this if you're really confident. If you're really comfortable with paperwork, you know, you fill in your own tax returns, you're happy with government paperwork, all of that kind of thing. Because if you get it wrong, the implications for a lasting power of attorney being wrong are actually worse than a will. Because ultimately, if you get your will wrong, your family can still decide to distribute the estate as you wanted it. Whereas if you get it wrong with a lasting power of attorney and then you lose capacity, it's as if you never made one. You don't have anybody acting for you. Or worse, if you get it really wrong, you've got the wrong person acting for you. So it is an area where, yes, you absolutely can make them yourself. But if you have any concerns whatsoever, particularly if mental capacity might be an issue for the person making them and you want somebody with a second opinion to back you up and do it professionally, then in that case, I would always recommend seeking professional advice. So just to cover off what they are, there's two types of lasting powers of attorney. Both of them allow somebody else or more than one person to make decisions for you if the time should ever come that you're not able to make those decisions yourself. I've put up their future insurance, and that's exactly how I would explain them. You hope they'll never be used. You hope you'll just make them, put them in a drawer, forget about them forever. But you just know that if you're in an accident, if your mental capacity should deteriorate for any reason, that you already have in place somebody nominated who you know and trust and have chosen to make those decisions for you. So the two types are quite separate to each other, and you can appoint different people to act under each. The first one covers finance and property, and this is administrative matters only. It allows people to deal with your banks, pensions, policies, property, basically pay your bills, collecting your money, deal with anything to do with finances. They cannot change your will, and they cannot make substantial gifts to themselves or to anyone else without the approval of the Court of Protection. They can make small routine gifts. So, for example, if you've been in the habit of making, Christmas presents to your nieces and nephews, and that was a long-standing habit, they can, of course, carry on with those. But they can't say, for example, oh, it's in everyone's best interest if I give 30 grand to myself. I mean, at the very least, they have an absolute duty to act in the donors, that is your best interests. And that is an absolutely strict undertaking that they take on. And when appointing them, you will know that they are somebody that you trust to act in your best interests. So although there are all these legal safeguards preventing them doing these things, I mean, ideally, you wouldn't pick somebody who would do that anyway. So that's the finance and property side. There is also then a health and welfare LPA that you can create, and that covers everything to do with, as it says on the slide, medical and social decisions. So that would be things like, on a medical sense, it might be what treatment you're prescribed or undertake. It might be consenting to an operation. It might be agreeing to you taking certain medication and not taking other medication. And in extreme circumstances, it could even be end of life decisions. For example, what do we take this operation? How long do we keep going? What decisions do we make? It doesn't compel them to make that decision. But if they want to, then it gives them the right to be considered as more than just a next of kin by the medical staff. And on a welfare and social side, it also gives them the ability to decide, if the time should come where that needs to be decided, things like where you should live. Do you receive care in your own home, or do you go into a care home to be looked after? And again, it makes them more important than next of kin in terms of being able to deal with social workers, medical staff, the council, anybody else like that. As I've said, you can appoint different people for each one, but in practice, I would normally advise people to appoint the same people, because you don't want somebody saying, oh, I want her to go into care, and then the other one going, well, I'm not going to pay for it. You don't want conflict in that kind of way. So it does happen sometimes that somebody has, one particular friend, for example, who's super good with finances, and the other one who they're much more intimate with on a personal level. And that's absolutely fine if there's a good reason. But normally, all things being equal, I'd recommend the same people. So once you've got these in place, you carry out these documents, and I'll talk about the procedure in a little while. But essentially, once they're registered, it allows that person to make decisions for you if you lose capacity. A health one can only be used if and when you lose capacity. Nobody can make health or medical decisions for you while you're able to make those yourself. However, the finance one can actually be used before you lose capacity with your consent and permission. So if you think, for example, well, I'd quite like to sell my house, but oh my word, I can't deal with all the paperwork. I could, but I don't want to. Then your attorney can use the LPA to act for you in that sense with your consent and permission. So in terms of the people who are involved in LPAs, there's you, and you're known as the donor. You're the person giving the power. You've then got your attorneys and any substitute attorneys that you might want to appoint if the original ones can't act. They are the people who make the decisions for you. There's then a role for a person called a certificate provider, which is a standalone role at the point at which you make the LPA. It's not an ongoing role, but it's the person who confirms that at that point you have mental capacity. At that point, when you sign the documents, you have the capacity to make that LPA. And that can either be a legal professional acting in their professional capacity. So I do it often. It does need to be somebody who has experience of working in LPAs. So it can't be, a litigation lawyer or, an employment specialist. It does need to be somebody operating in the private client field, or it can be a medical practitioner, again, operating in a professional capacity. So your GP could do it, any kind of specialist. Often if somebody's, for example, been diagnosed with a condition which could call capacity into question, then they'll be under care of a specialist who will be able to say, well, yes, they have this condition, but this doesn't affect their capacity. They're perfectly fine. And they would be able to either act as certificate provider or provide a letter of evidence, for example, that could then be used by me, for example, in then preparing the paperwork. It can also be, however, somebody personally known to you, not a professional, but somebody who's known you personally for at least 2 years on a close personal friend basis. I would say when picking a friend to act in that role, to make sure that they are willing, if the point came to it, to actually stand up in court and say, yes, they had capacity, because ultimately that's what it might come down to. It usually doesn't, but it does need to be somebody who will be confident in their assessment and confident standing up to it later. You can provide letters of wishes to accompany the LPAs. The LPAs themselves tend to be a very strict format. It's forms mainly that you go through, and then there's a very strict order in which they have to be signed. But you can put letters of wishes or your preferences alongside them, where you can put the kind of softer side of guidance that you would like. So, for example, you might be appointing your attorneys to act for you in a health and welfare sense, and that's all the document will actually say. But you might want to do a letter of wishes, and again, we can help with drafting that, where you say, well, in this circumstance, I would prefer not to be resuscitated. In this circumstance, this is the kind of medical treatment I would like. If I lose capacity, I would like to be cared for at home for as long as possible. I would only want to go into care as a last resort. All of those things that you can put, which will give your attorneys guidance in how you would want to act. Again, nothing substitutes a conversation, but actually when people are making those kind of really difficult decisions for you, it does help them as well to have it on paper to remind them that they are doing the right thing, particularly where it's these kind of really difficult decisions. So once they're created, you register them with the Office of the Public Guardian. That's literally posting them off with the registration form. They charge £82 per document to register it. They'll then send you the original back, keep it safe. You can make certified copies, and I'd always recommend getting some certified copies, because then they can be the ones that you post off to banks or whatever. Just keep the originals safe. Okay, right. If we could just then move on, I'm going to talk a little bit about probate, which is the flip side of the coin. This is once everybody's made all these decisions, set up your will, decided what's going to happen. Sadly, everybody then passes away, and then your executor has to deal with what is left behind afterwards. And often it can knock people sideways, because until you've been through this, it is not something that most people know anything about whatsoever. And a lot of my job is speaking to bereaved families and literally starting right at the beginning, very, very gently with, let's talk about the funeral, let's register the death. Don't worry about paperwork right now. This is family time. And then we slowly work into the paperwork. And to be honest, that's where I tend to say, look, do you want me to do this? A lot of people either feel I can't deal with paperwork. I'm just not very good at paperwork. Yes, please do it. Or they might think, I can't deal with paperwork right now. I'm bereaved, I'm distressed. I can choose hymns for the funeral, but oh my word, I can't deal with pensions and utility bills. Please do it for me. Or, as I mentioned earlier, some people just appoint us straight out. And so we would take on all of this. We'd contact the family and say, do you want to go and have a conversation with the funeral director and, you know, choose the flowers and the hymns, send us the bill and we'll deal with everything else. So it can be a very varied set of instructions, really. If you need solicitors' help, they can help with very little or everything, as much as you need. But these are the initial steps, essentially. Register the death. You need to make an appointment with the register office. They'll ask you details about the person who's passed away, you know, their name, their marital status, their occupation, date of birth, date of death. Please make sure you have all of that accurate before you turn up, because it is a nightmare getting them amended, particularly in dates. They require evidence, they require witness statements, all sorts, to get them amended once the actual death certificate has been issued. So please make sure that's accurate when you report it. They will offer you a chance to do the Tell Us Once service, and this is a government service where the registrar will enter the deceased person's details into a wider database, which alerts most of the big UK banks and certainly any kind of DWP pensions or benefits, HMRC, council tax, all of those kind of things. It won't do anything in terms of taking things forwards, but it will freeze it, which stops overpayments continuing, for example, stops them bothering you while it's a really difficult time. Other things to do on the initial steps: secure any property. You know, it's worth making sure you know who's got keys to the house. Are there any valuables that need looking after? Have a look through the paperwork to see if there's anything that needs securing. And arrange the funeral. The funeral is one of the only debts that can be paid from the deceased person's finances before probate is issued. In a lot of cases, banks won't let you touch funds, but they will pay a funeral. A lot of people don't know that. All you need to do is get the funeral director to send it to the bank, or send it yourself to the bank, and they will pay it directly, which can be a big relief to people when they're struggling to think, well, how am I going to pay this out of pocket at this particular time? The next steps when you get into the estate administration is really the dealing with everything stage. You need to identify what there is, value it, look at any assets, look at any debts. You may then need to apply for a formal grant of probate. This isn't always needed, but if you have bank accounts over a certain level, if you need to sell a house, if you need to sell shares or investments, then usually you will need a grant of probate. This grant is just a certificate issued by the probate registry, and there's a little picture of one here on the right. It's just a one-page certificate, and it says, yep, we've checked out everything. This is the deceased person. This is the person who's applying for probate, the executor of their will or the next of kin under intestacy. Yeah, we've checked out everything. They've paid all the inheritance tax that they're due. Here you go. And they'll give you this certificate, which is your authority to act for the estate. And it means that when doing things like selling a house or selling shares or closing high-value bank accounts, it means that they won't then, those third parties won't have to go through the whole rigmarole with you again, checking out family trees, examining the will. They can use this grant of probate as taking it as read that you're the person they can deal with. Paying inheritance tax is something that you have to do. And you have to do that even if you don't need probate. You still have to pay the inheritance tax. The deadline for declaring inheritance tax is 12 months from the end of the month of death, but interest will start to run on any tax payable from 6 months. Everybody has £325,000 tax-free when they pass away. And if a married couple leave everything to each other, then it's exempt on the first death, and the second death they get double, so 650,000. Unfortunately, that only applies to married or civil partnership couples. So if, for example, you own property with your sibling and you leave everything to them, it's just the 325 and it's lost. But between spouses or civil partners, you can transfer any unused nil rate band. There is also 175,000 tax-free residence nil rate band, which is where somebody leaves their home to direct descendants, so their children or grandchildren. It's a very, very narrow allowance. I don't know why they made it that narrow, but they did. But it means essentially a married couple leaving everything to their children can have up to £1 million, whereas a single person leaving things to nieces and nephews will only have the 325,000. So there are a lot of tax planning areas where you can work on passing it during your lifetime or structuring your will in a particular way. But it is worth just remembering that the variation is quite significant depending on your family circumstances. And then finally, once you've got probate in place, then gathering in everything, collecting in the bank accounts, selling property, selling cars, dealing with everything, distribute it to the beneficiaries under the will. Who is it due to? And that's the whole procedure, really. In terms of how we help people, I do everything, as I've mentioned, from the initial steps right to the very end, and most solicitors will do that too. But a lot of them, and we certainly will also help just with that middle bit. A lot of families come to us and say, look, I'm fine dealing with banks. I've already dealt with the pension, but oh my word, court, probate registry, tax? I don't think so. And so I can help with them with that on a standalone basis. They give me all the figures. I do the court application, give them the probate at the end, and then they can go off and deal with the house and everything else. So that can be quite a useful service as well. And most solicitors will be able to do that. And certainly we do, usually on a fixed fee as well, which obviously really helps with transparency when you're looking at costs. So that was the end of my substantive talk. If you want to go on to the next page, I think is the final one. Then these are our contact details. So willsandprobate@slatergordon.co.uk. That's our team email. In practice, it's just me at the end of it. But if I'm ever on holiday, then the rest of the team have access as well. So it will get dealt with. And please feel free to email us any questions on that. You know, we don't necessarily charge for just as answering, you know, little questions that people might have, or just you know, points of interest that you might have. And if it does obviously then translate into work, then we'll send you all our professional client care stuff and everything like that. But do feel free just to contact us with any little inquiries that you might have, or give us a ring. You know, I appreciate people might prefer to speak to us rather than send an email into the ether. So there's my direct phone number, and of my paralegal Brooke, who can also help in my absence. But yeah, do feel free to come straight to me. I'm just looking through the questions. Major will about 20 years ago. Yes, even if your circumstances haven't changed, I would recommend reviewing it, because sometimes the law does change. So, for example, any couple who made a will before about 2007 will have been advised to leave their property probably into trust in order to protect their nil rate band allowance for inheritance tax purposes. Now, in 2007, that's when the law changed, permitting it to be transferred between spouses. So if you still have that kind of trust in it, actually, it is worth updating your will, because otherwise it just creates extra paperwork, which means extra cost for your family when you pass away. It's also just worth updating it. You know, for example, if you had small children when you first made your will and they're now adults, you might want to make different provisions, or if you now have additional family members, you might want to make more provisions as well. It might be that the people you appointed as executors 20 years ago are actually now aging and actually maybe less willing or able to act, or you might be concerned that they even pass away before you, and actually now, rather than appoint your parents, for example, it might be appropriate now to appoint your children, something like that, or siblings or friends. But for those reasons, it is always worth it. You don't have to do a professional review, but it's worth getting it out of the packet, reading it through and saying, yeah, actually, that's fine.
I have a question that I thought about when you was explaining about your funeral wishes, but that made me think about funeral plans, you know, because I see a lot of things. What's your sort of take on, should you have a funeral plan, or would it be more advisable to put your funeral wishes into your will?
Having a funeral plan is a good idea. It means that you yourself are specifically choosing your wishes. And particularly for people who have strong views on, you know, specifically being buried or cremated, and definitely not the other one, for example, or I definitely don't want this to happen, or I definitely do want this to happen, then buying a burial plot, or making arrangements with a funeral director for the scattering of your ashes in a particular place, and getting permission if it's a private place. Sorting all of that out just means that you have confidence that that is what will happen. It can also give people financial confidence that if they pay for it during their lifetimes, then it will mean that regardless of what happens to their money before then, they know it's already paid for, and what they want to happen will happen without leaving their family out of pocket. However, if you don't really have strong views about it, or you know your family will carry out your straightforward wishes, then you actually don't need to buy a funeral plan or anything like that. You can just make a list of wishes if you want to write it down, if you think people might forget or not have confidence to follow it through. Then you can just, write a bullet point and leave it with your key paperwork, as long as you know that somebody knows where to find it.
But I was thinking along the lines of, what song do you want?
You can do that. And I keep mentioning letters of wishes. I mean, but we do these to accompany all kinds of formal documents. So the will or the trust or the LPA is the skeleton. It's the bones of your wishes. Yeah. But then you can also always write a letter of wishes. And I, again, have drafted them for particularly for people with particular religious views, for example. Yeah. Yeah. But also, as you say, people with just strong views about what they want. They might want to choose the readings and the music. And that's absolutely fine. And to be honest, particularly if you're appointing a professional as your executor, there is nothing personally that I like better than seeing that entire long list, because then you know that you can give that person exactly what they want. I mean, if you're at the point where I'm choosing your hymns, then, obviously we put loads of care into it and everything, but I don't know the person. Whereas having that guidance, even if it's a friend organising it or a neighbour or anybody, having that guidance is worth a lot.
Definitely.
Yeah.
We're getting some really lovely feedback saying.
Yeah, there's some nice comments coming in here as well. Also, as well, just more of a comment than a question, but my dad sadly had a stroke a few years ago, and his last 2 years of his life were really, really difficult because, he went into care around COVID times, went into emergency care, and obviously had to stay in that because of the time. And the last 2 years were so difficult because he lost a lot of his capacity. So having the power of attorney was a lot easier, having that in place. So I could look after stuff for him, and even from afar as well, because we didn't live in the same area.
Yeah.
So these things are really, really important. And I'll be honest with you, they're things I and probably hundreds of thousands of other people don't like talking about as well. It's sort of scary, isn't it? But that process, it was made easier by having it all in place and having it all right as well.
Yeah.
And also,
absolutely.
I
always say that actually one of my jobs is to make you have that hard conversation, to make you make those difficult decisions. And yes, I ask horrible questions about, what happens if all your family are in the same car accident? Well, what happens then? Well, what happens then? And it's not, it's not a nice job to have, but it's a very responsible job to have, because it forces people to think, well, okay, what do I want to happen?
Yeah.
I don't want to leave it to chance or for the law to govern. Under intestacy, if I don't leave a will, it will just go to my next of kin, whoever the law says that is. I don't want to leave it to chance. And so that's why it's my job to ask all these questions and to put people on the spot and say, go away and think about this and make your decision and come back to me. Because then once they've done it, that sense of relief for having made those decisions and put everything into place and got it all wrapped up, put it in our archive, put it in a drawer, do whatever, never need to think about it again. Well, that's true, for between 5 and 8 years, and then I would recommend reviewing it. But but you've got that sense of relief that everything is dealt with. It's not forever hanging over you. Oh, I should do that. Oh, I wonder what happens if this. So it is a really difficult conversation to have. You're right, Mark, and lots of people don't like talking about it. But that's where actually seeing a professional can help you kind of see it objectively rather than emotionally.
It's certainly the process that we went through with it, because we actually had one, and then I just didn't feel comfortable that it was exactly what we wanted, so we went somewhere else. And it's not the greatest day when you're doing it. You're having to think about all sorts of those, but once you've done it, that sense of almost relief that whatever may happen, you've got that in place, and it's not just for yourselves, but it's for the people that are left behind, and I just feel it's so much better if you can get something in place. Lots to think about and very helpful. So that's been brilliant. Well done, Rachael. That was amazing.
Yeah.
And you sound so knowledgeable and trustworthy. I feel like I could come to you, and it's just will be all done and organised.
yeah, that's true. And for anybody who's watching the first time and hasn't seen the Slater and Gordon webinars, this is the reason why we've teamed up with these guys, because everybody is really personable, everybody's really friendly, and we don't feel like we're talking to somebody who's complicating things. So we've got so much from these sessions. We hope everybody else has as well. Obviously, Rachel's put her details in on the screen there. We'll also put them on all of our links on social media, on a YouTube channel where this recording will be. So if you want to get in touch with these guys, please do, because as I say, they'll answer any questions for you, and they'll answer them honestly, and they'll answer them clearly as well. And that's certainly what we've found in our experience.
Absolutely.
Yeah. So just to finish off with Brain or Shine as well, if you want to get any of our resources, we have a regular podcast. We also have these webinars. There's another one in a couple of weeks, and I can't remember the date of it. It's 2 weeks today.
2 weeks
anyway.
today. There you go,
enough.
whatever that
2
is.
weeks today.
I was trying to desperately
We can
remember.
work that one out in a second. That's a lived experience one. So Jules and I will be hosting that one. And we have a YouTube channel, we have an Instagram, and a peer-to-peer private support group on Facebook. I'm trying to think of anything else, but just go to brainOrShine.com and you'll basically find everything we do on there. And if you need to get in touch with Slater and Gordon, obviously reach out to them, or you can do that via us and we'll point you in the right direction of who you need to speak to. But Rachael, thank you so much for that. That was really, really easy to understand. I'm the guy with a brain injury, and if I can say that, then it's true. And we really, really hope that everybody else feels the same as well, judging by the comments. Sounds good. Thank you, everybody. Have a really, really wonderful evening. If you're watching this back again on demand, then have a great time of day, whatever time it is. We'll see you soon.
Bye for now, everyone.